because anybody can do it. You just have to, on that second page, there's criteria. You can get ACP if you are a victim of domestic violence. It doesn't mean that you have to have a protection order or anything documented. If you consider yourself a victim of domestic violence, stalking, harassing, if your abuser is part of law enforcement and they have access to um, your address on, you know, county websites and the ability to search things, you can become part of the program if, yeah, your abuser is part of um, law enforcement of some kind. Um, and also, if you are a public figure and you're experiencing stalking, like if you are, oh, what's a public figure? Mayor. Yeah, and if you've experienced stalking as a mayor, you can have your address confidential. Um, like even politicians, um, they can be part of that program too. And you're just checking a box. It's not like you have to prove anything. It's just what you consider. Uh, I've never had somebody denied or had this confidentiality program, but I have seen people get kicked out. If you don't get your mail on a frequent, timely basis, they will kick you out. But anyway, back to this. Um, so how will getting a protection order affect your finances? Silly. I'm not trying to talk somebody out of getting a protection order. I just want them to think about uh, the ways that it might affect their life that they maybe haven't thought about. And maybe we can make the protection order less restrictive or more restrictive based on the conversation that we're having. Um, and then this also will lead, if they're worried about financial stability, that's when I can step in as an advocate and give them additional resources and options of how to um, supplement that income, or what we can do at SafePlace to um, provide them some stability for a second. But that'll lead me into other advocacy um, as we're going about this. Employment, it is a victim. If you are considered a victim of domestic violence, your employment, if you got fired or something for maybe like they're like, you're going too many court hearings, dropped at any time, but um, that doesn't likely happen without the input from the victim. The victim is fearful, then they'll most likely just keep it in bed. They don't have to rehash new evidence or anything like that. So yeah. hmm A lot of jobs won't hire you if you've got a protection order currently standing, or even if you've had previous ones. You can be turned away at the border. They will. It'll be on your. Yeah, a lot of people can't go to Canada if they've got protection orders put in place. Um, yeah, yeah. Temporaries will kind of dissolve. hmm Because that temporary hearings, the judge is not finding you, um, isn't making a ruling. So once you are found to be um, an abuser, whatever you call it, a defendant, you were in the legal eyes guilty of domestic violence. That's when they will follow through. But yeah, I mean, and claims, customs, it can affect a lot of things. Your employment. And the commissioner cannot take any, um, like even if you're saying, I move, I'm the respondent, I'm the one being accused, I moved 3 states away, I have no transportation or any way to contact them, and I'm going to lose my job that I've had for 25 years. The commissioner cannot take into consideration any negative effects that it might have on you if you are the respondent. Doesn't matter. I don't care. Cry me a sob story. Um, they cannot, and it can't be a distance thing. It cannot be a financial thing. It cannot be an employment related concern. They can't consider the negative effects it might have on the 6 months. So like somebody asked me the other day, uh, they're like, do I have to get a protection order in every state? Yeah, every county or something like that. Absolutely not. No. It's anywhere you are, whatever is in that protection order should not matter where you're at. It would be important. I know. Could you? Yeah, I'm trying to go grocery shopping in uh, Lewis County. I got to go file for a protection order. So I could do that. No, it closes in. All right. What time is it? Break time? Let's take a. Yeah, because I don't have much more to go. Oh, okay. I'm good. What what TV service do we have connected to this thing? Um. Oh, I was gonna get copies of our consent. Let me go get. I guess it's okay. So, um, the one thing that I have to cover during ACT is talking about our consent service form. So this is kind of separate than what we've been discussing, but we'll just go over. You guys already are familiar with these, but this is just the first thing you go over with clients before we get into the nitty gritty of why they're here. Um, and for different legal reasons. So we've all seen this and heard this, but oh, let me know if you have any questions as we go through it. But you have the right. This is what we're going to be talking to the client about before. Just talk about anything else, but you have the right to receive certification regardless of race, color, religion, disability, pregnancy, national origin, sexual orientation, gender, age, ethnicity, veteran status, marital status, immigration status, or any other basis prohibited by law. And you have the right to receive services that can be chosen. It's pretty standard. I moved off. Um, your information is privileged and confidential. Um, you have the same privilege that attorneys have with their clients. Um, there are times where, like I've been subpoenaed as an advocate in my um, previous agency, and when that happens, we want to, we'll have to reach out to SafePlace's attorney to get rid of that. So you ever come across that, or you do get a subpoena, because uh, like mine was like about sexual assault, and they wanted me to be a witness, and we had to fight against that. Not because I don't want to support that client in any way possible, but just because we need to maintain that confidentiality. Victims need to know that they're safe talking to us and confiding with us about certain things. And I don't want to be included in any legal related anything as an ad. So if that ever comes up, you just follow up with, man, so they'll fight. Stars and the will fight to get rid of that. But it does come up. Um, so the law guarantees that all information you share with SafePlace advocates is protected. Under this law, advocates may not, without the consent of the victim, be examined as to any communication between the victim and advocate. You are the only person who can release your information. So this is blah 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 blah, all the boring stuff. But Even when like our grantors are auditing our files, we have to redact all client personal information before they can even review that. Things that we document in SAW, like their demographics and stuff like that. Again, there is no client related information, like personal identifying information on there. That's just for demographics or funding purposes. And you can explain that they're asking you why. I'm asking your um, gender. Okay. And then, of course, there are going to be some circumstances where you have a client that wants us to release information. And that's when we will give an ROI. ROIs do have to be very specific. So if a client is wanting us to um, maybe verify that they're receiving services, um, or it has to do with like a GPS case, and you need to verify that maybe SafePlace is providing the income at their new residence. Um, that's all fine and dandy. But if they ask me any question that I don't have permission to share that's listed on that ROI, I cannot share it. So it does have to be very specific. And they can put a time frame on that. They can leave it open ended and just and forget about it, which normally what happens. Um, but if there is a time frame on that, then we have to note that. Uh, but you'll encounter um, clients wanting us to share information with other agencies or applicants, and other agencies will call, um, try and get information. We just, our response is like that email that I sent you guys the other day. I can neither confirm nor deny that that's a client of ours. If that is a client of ours, they need to sign a release agreement. They do have to do that in person. You can imagine. I'm not going to take some stranger's word over the phone when I have no idea that's the correct person, because maybe I've never met them before or anything like that. They have to come in person, be able to show ID that they are who they say they are before we're releasing information during it. Um, so Charlotte asked me this the other week. It's down legal aid. Like if they're at legal clinic and they're wanting to like there's a lot of times where they will come and give me information that they think I need for our records or something, or they want to say that's not their real name. I can you can they can tell me that, but really I'm not doing anything with that. And sometimes down legal aid will ask you for information. And even though we work together and we partner together, we are completely separate agencies. And you cannot talk specifics about anything client related without an ROI. Um, yeah, something to verify they are the using the name that they provided to us that we use, for records. Yeah, I mean, um, so yeah, absolutely. Any most of the time I know them. I work with them directly, so I'm not going to make them send me their ID. I know you are the person I talked to last week. So, um, but like Ashton's not going to know who our clients are, and so they will need to see ID to match that. Um, so what did you ask? Did I answer it? Good. Okay, so all right, and they have the right to access the file with ID. In the person's basis. So we keep Note House, um, notes, um, and we can verify services based on like what's on their stuff. But their scan client file is really just paperwork. So I mean, there's sometimes where they want like absolutely any document that says that they came here and received any service. And I literally have to go through Note House and write the dates and the service. Um, and it is a pain in the butt. Back in the day, we did not have digital and client files. We had physical um, files that we would keep and track services and paperwork and all of that. So it was a lot easier to say, okay, I can just copy my paper file and give it to you. But now that we use Notehouse and Soft, we kind of have to do that work ourselves. No, and we're see that's some advocates put like endless notes, very like specific conversations and like quotes from clients and things like that in Notehouse. I was always trained and taught keep it the bare minimum. I need the next advocate to know where I left off, but the less information that I put in there, the better because there are things, I mean, subpoenas do happen. And there are certain situations where we do have to put in all the nitty gritty. And the less information I keep is better for the client because what if an advocate's in there putting like um, I've seen notes in basically some like mental health issues and like explaining like the advocate's perception of what's going on. And if it's a safety concern or a boundary, that should be noted in there. But I don't like to put specific information in there. That could be a detriment to my client and unrelated to what I need, the information I need to do whatever task I'm doing with them. So I try and keep it bare minimum. I need the advocate to know where I left off, but I don't like to put any more information than is necessary. Intoxicated or yeah, yeah. But I don't need to put that's not relevant to anything. And you are going to encounter all walks of life, all mental capacities. Um, and I'm not going to put my opinion on a note for a variety of reasons. I think it's disrespectful. I think that's, I'd rather keep it to necessary things. All right. And on going. Wait, oh, now it went back. All right. So please be aware of our limitations. SafePlace is legally obligated to report information to authorities that tell us about child abuse, abuse of a vulnerable adult. If you are harm to yourself or someone else, then we have to report that. We are mandated to report. And a lot of people will come in here and want to talk about maybe abuse that happened to their children. I need them to know this first and foremost because I want them to be able to decide what information they share with me and how they share it with me and how they that. I hate making CPS reports, but also um, CPS reports and being a mandated reporter is super important. I'm needing to think of the welfare of a child, and I would rather be, you know, better safe than sorry. I would rather make a report and it wasn't maybe necessary or than for me to fail to make a report and a child is not. I'd rather apologize for I wouldn't, but I would rather mentally apologize for maybe making a mistake or taking a step too far than to risk harm to that. So, but if you ever question whether you should make a report or not based on whatever information you got, please um, don't make that decision on your own. Grab somebody else and kind of make a decision together, or grab me, and you can work through that together. But if they hear that information and they still want to tell you, you're still going to have to follow through on it. Um, ah, and then adults who have guardian appointed appointments to make personal decisions need written consent by the guardian, except for when the guardian is the alleged abuser. Um, Only guardians legally identified as responsible for health and well-being may provide consent services. A minor survivor, 13 years or older, may use SafePlace advocacy services without a parental consent and may give SafePlace written consent to release information. Also, at 13 years old, you can make your own medical decisions. That's what that is. That age is. Only one parent or legal guardian signature is required, and the minor is under 13 years old. And but if their guardian is their abuser, we don't need a signature to see what we need to do. And I know you've heard this yesterday and a few other times. Um, I can't speak for other programs, but by law and what we do as advocates is we serve everyone. Doesn't matter their age. It'll change the way we get that referral and that information. So, like, we do work with kids of all ages. Sometimes it's supporting the parent, age appropriately. But they're by law, children at any age that are cognitive enough to be involved in like detective interviews and prosecution interviews have the right to an advocate there. And a lot of times the parent cannot be in that room. So it is super important for an advocate to be present because not all prosecutors, detectives, law enforcement are very trauma informed or informed in sexual violence or domestic violence, right? So there are times where they will kind of push a child in that process, in that interview situation. And you'll notice if they are super overwhelmed or they stop talking and they are, you know, and it's our job as advocates to be able to say, let's take a time out. Let me go get some water. Let's go get some fresh air, and then we can come back. But if an advocate's not present, that detective is probably going to push that a little bit further. And we really need to be there to advocate for our clients. And a lot of that is sometimes that they don't notice when somebody's very uncomfortable or going into a panic moment. So somebody should be there to be able to take breathers and speak when somebody can't speak for themselves in those situations. That's the same when you go to the hospital and you're responding to sexual assault or non-fatal strangulation. Not everybody is very trauma informed, and my or maybe they're just having a bad day and they're not treating the client with respect or dignity, maybe cutting them off or like not answering questions that they have for whatever reason. There have been times where I have politely asked the same nurse to step out with me, and I'll just say, um, we need to give them a minute, or can you give us 2 minutes so I can talk to this person and I can have a conversation with the client if they are comfortable with what's going on, or if they are completely uncomfortable, if they need to stop the exam. Um, but I have had to take out nurses, and they were being completely inappropriate and just rude, and I'm making a terrible experience even more terrible. And I have shut that shit down. Or sometimes I'll get, I'm not sure. And so I want to take a breather so I can talk directly with the client, get what, maybe they are completely comfortable, and I'll just say sweet, and then we'll move on. But that's what advocates are there to work and make sure that we're not missing prescriptions, Yep. Hmm. Yep. Uh, if um, like Jen's really amazing. Like she'll proactively do that herself. There's other commissioners that you get that are not so friendly. So if I see like my client, we're like on the stand in the middle of the hearing, and maybe they like are in fight or flight or they froze, we'll take a recess, and I'll just say, can we take a quick recess? And they'll nod their head, and we'll continue this. Um, and but that does, or if they are emotional, like just sitting. Let's take a breather. I mean, sometimes they should be fast for sitting next to their abuser or abuser's looking at them. Like, let's take them out of that situation, um, and do some kind of thing. Mhm. I would just whisper, "Do you want to take a break, or do you want to push through?" Because some of them will just want to get it over with. But I'll just whisper. And then if the judge asks you, the said, you just say, "Can we take a break?" I've never had a commissioner like call me out and be like, "Certify what I did," but so it's not, but it's just saying a big thing. Yep, please. It's just Mhm. Yeah, that's why I make sure they know before we go on that stand, even if it's just like while you're walking up there. I just want to remind you, I cannot speak for you, and I cannot answer any questions or concerns that you have during the hearing. I got to be silent. I'm just here physically for support. I mean, I've had, and that was different from other people. I try not to ever like reach out and cut somebody without their permission. But I mean, I've been in court where I've got a client with a dead grip on my hand for an hour during the entire hearing, not letting go. I mean, and you're feeling and everything. If they want to reach out and touch me, hold my hand, grab my hand, I'm okay with that. But everybody, you're your own individual, so that's up to you. Sometimes I'll rubber their back even while they're speaking and they're just like bawling or something. I will sometimes if you do, gently pat them on the back, kind of takes me out of that response, and ground them a little bit. So it's just techniques that you have and that you're comfortable with. I try and always let them know before we go on to that stand that we cannot speak to you or answer any questions or concerns. If you need to take a break, you can let me know, or you can ask the judge, and you can ask me something out there, but not while you're on. That's okay with you. Um, even remind them of that while you're up there on the stand, um, and the mic is there. That's okay. Say it verbally. Um, I can't answer your questions right now during the hearing, but we can follow up back. So, yeah, I can answer it. Again, that's the ROI, that's the information, the complaint, the number there. That's just uh, the first thing that we go over with our client. Any questions on our consensus services? If it's legal clinic, down legal aid, they have their own consensus services stuff. But if we are meeting a new client and we're going over this information, really, we should be making a copy of their signed page and giving them a copy of that. but not everybody wants that or cares about that. But you should, if you remember, you should offer. Otherwise, it's going to be in their scan client file and we can print it out later for them. Um, but try and remember to offer them a copy. You know, anything that is signed, they need a copy of it, or at least be told they can have a copy of it. So with mandated reporting, here are some of SafePlace's rules. So all SafePlace staff, employees, and volunteers are mandated reporters. Um, and when any SafePlace employee or volunteer has reasonable cause to believe the child has suffered abuse or neglect, and there's the RCW says what that is defined as, he or she shall report the incident or cause a report to be made to the proper law enforcement agency or CPS. The report must be made at the first opportunity, but in no case longer than 40 hours after the report. You should be doing that almost immediately. And I gave you guys directions on the form that you need to fill out, and it also needs to be attached to there and on that tracking sheet on the daily log. The report must include the identity of the accused if known. Try and get as much information as you can, but sometimes you're working with like a first name, and you just get it off your plate. You did what you were supposed to do. You gave what information you had, and get it off your plate. When there is a reasonable cause to believe that abandonment, abuse, financial exploitation, sexual or physical assault, or neglect of an adult who has guardian appointed to make personal decision has occurred, SafePlace employees or volunteers shall immediately report to proper law enforcement. That could be considered like a vulnerable adult situation. So, the children and vulnerable adults. If you have any question in your mind about if it was considered neglect or not, then just grab somebody else to make that call. Don't make that call on your own. So we're all familiar with Resource Hub. That is where I go to for most of the resources. But again, all of these are legal resources that we get out all the time. So certain county court liaisons, they can help with protection orders and filling out forms. All of the forms that you can that have to do civil related, you can print off for free from that Washington court courts.law.gov. So if they don't have like a printer at home, or if they don't want to pay that huge fee for whatever packet, like dissolution, like you have to pay a fee for that. Not protection orders; those are free. But that's when they can use our computer room. They can print out documents. I print out dissolution packets and parenting plans all the time. Protection orders, all of that's on there. If you need, like you kind of understand it, the Washington Law Help will kind of put in the directions in layman's terms for the basic person to understand the process. So Washington Law Help will really help explain things that, if they're at home and they're just wanting to do some research on their own, it's a less confusing language. And then again, Northwest Immigrant Rights Project is who we send all of our immigration situations to. If clients needing additional help, but so all that is on our research. Oh, that is all that we're gonna go over some scenarios here, and then I am pretty much done. If do you have any questions or concerns or anything that you want to ask? But again, I will have additional training for you guys to actually go through protection orders and how to fill that out together here. So all of these be your own individual prison training. But so at least get you. Um, so we can't give legal advice. So it depends on what they are. If they're wanting like parenting plans, if they're wanting, I'm not going to fill that out with the client. Text orders are kind of different, but really to be in their writing, I can explain language. Um, if you know what you're talking about. Um, I can explain language. I can explain what they're asking. Like there's things like in legal forms, pages have to be one sided. You can't have double sided. Like you can't write outside the margins. Um, blue or black ink. There are like certain things that I can help with and um, kind of explain what it's asking if it's confusing. But they should be physically writing it themselves. If for whatever, if they have some sort of disability, and they can't write for themselves, then sure, I will use their exact words and translate and write down exactly what they're saying, but it will have to be in their. I can't guide them on what to answer, what to put. I can tell them like what the court is looking for, like the protection orders. They need to know it's a pattern of abuse. It does not have to be physical. There's no time frame. It doesn't matter when it was. If you are fearful currently, and you have evidence to um, show that it is a pattern, not a one-time incident, um, then that's the only criteria they need. Um, but um, I can't go anything beyond it. That would be considered. Okay, so when thinking, I'm gonna read some scenarios. All of these have something to do related um, legally, and so as we're going through these, I want you to think about points of advocacy, maybe things that you might suggest or point out. What steps could they take, or any additional things that you think are relevant. We'll break it down a little bit, but um, and some of these I should give a disclaimer. I did not write these. Um, I Some of them are very kind of graphic, so I don't. I'm just this is not really sort of one. Because not all of them. I mean, some of them are sexual assault related, and some of them are domestic violence. Okay. Are you guys comfortable like taking one and reading it, and then we can talk about it? Um, yeah, I don't. Just take one. You know, and if you take one. If you're not comfortable reading aloud, you don't have to. My voice gets it, and then I'll read. We don't have to read all of them. Let's just go through a few of them. I'll start. So this is regarding. Oh, and that top little, the first little word on there. What is it? Yeah. So all of these are kind of different situations. Um, so this one has to do with reporting. So you have gone with Lupita to make a report to the Lacey Police Department. Her child was sexually assaulted by the babysitter yesterday. It was a hard decision to make a report because the babysitter has been a trusted family friend for many years and an integral member of her small Guatemalan immigrant community. Lupita speaks good English, and you can work with her easily without an interpreter. You and Lupita are in the lobby waiting for an officer when The officer comes out to take the report. There are other people in the lobby coming and going, and an officer as a receptionist is answering, ringing phones, talking, and transferring to various departments. You and Lapita are seated in a chair, and the officer does not take a seat as he begins to ask you questions about what happened, taking notes on small pad as he stands legs apart in full uniform with a gun. He's to the point, but not rude, and assures her he is there to help her. He does not introduce himself, but proceeds with the interview. It seems Lupita's English starts to become more strained as the questions become more specific, requiring answer that she's having trouble translating or finding the right words to describe the meaning. In this scenario, you do not speak Spanish. Lupita becomes more overwhelmed and distracted by the noises in the lobby, and her focus is um, waning, and she has asked the officer to repeat the last question 3 times now. Based on her rights, what points of are there of advocacy? What steps could you take? What are other points of advocacy that would be helpful in this scenario or after you finish these? That would be um, the advocacy in that. I do for sure. Because I mean, they have a right to privacy anyways. That would just be completely inappropriate to have that conversation regarding sexual assault in any presence with anybody present. It's super important for that to stay structured situation away from others. That's probably, I wouldn't be rude. That's probably how I feel about it too. I don't want to call the police officer out or be disrespectful. But I did probably, "Oh, I didn't get your name. My name's Kayla. I'm an advocate. I would, yeah, exactly. Yeah. Um, Anything else you can think of? Yeah. Because sometimes people can understand English um very well and be fluent in a lot of aspects, but under pressure, um, it's hard for you to focus your mind into that translation. And so if I was noticing that they're becoming strained in answering, um, I would ask if there's an interpreter available for them while they do this. And plus, uh, not only is it their right as a victim to have that service offered to them, but legal language is very specific, and so you don't want to leave any room for interpretation. Um, so we would just have to address that part too. Mm, Really, that's the main point there. Um, hmm yeah. Um, I've never encountered a situation like this. Normally, you are in a private room, so hopefully this won't happen. Um, mhm. Yeah, I've been to. There's one situation like a couple months ago where the client, they had a protection order in place, and it was constantly being violated by not only the respondent but his family, um, uh, like finding out like her dog's social media and like messaging through that because they were blocked on everything else, and they were trying to report it to the police. They tried dispatch, the non-emergency number, and this was like ongoing. It was multiple times, and they're like, they were like, nobody is following through, nobody is calling me back, um, yada yada yada. And so just in there, I got my work phone. We called up this the non-emergency line right there, and I just said, I'm an advocate in SafePlace. I'm just trying to. I have a client here who is trying to make reports of this the you know situations, the violations on a current protection order, and 5 minutes later, detective was calling her back. Sometimes, I mean, sadly, sometimes it needs. That's why we. I mean, I wish we didn't have a dog. I wish this didn't exist, but it is so needed. I don't know why I needed to be the one to make that follow through happen, but it happened. Um, I've been to detective interviews at OPD right down the street, literally like a block away, thank God. Um, but yeah, sometimes they will need just support making that initial report, that police report, um, and we need to be able to be there for them next. All right, you wanna go? Three doors. Okay. See your point of view. Yeah, for sure. All of those points I would definitely address. Um, there are situations where you will get ignored as an advocate when, like, the prosecutor did not invite you back. You just get up and you go. If they ask you who you are, you just identify yourself as an advocate. Doesn't have to be formal, like, not to be calling you out or disrespectful. You're just gonna step along with your client. I don't care if you invited me or not. Like, here I go. That's my job. But you do have to be vocal and you do have to be proactive. Uh, I'm not gonna. That's just my job as an advocate. Um, yeah, but I mean, there are a lot of accommodations that can happen at school regarding safety. You can get um, that's what you should do. That's what I would ask the client to do if they're comfortable sharing that information. Your school should know. Plus, it's a probably protected on that restraining order, so they should have a copy of that anyways. Um, but mhm. And you can get a chaperone to walk you to your yeah, security to walk you to your classes um, or to your car after. I will always recommend parking in the wellest lit, publicest place possible. Um, so there could be witnesses and things like that. But if you are already in that prosecuting interview, and I would encourage the victim to mention those concerns while with the prosecutor. Um, that they are being erratic. You don't know if they're um, what they might do right now that this is an escalated situation and they're very angry with you and vocal about it. Because the prosecutor might have different solutions or options, but Vine would be on those too, so they can get notified when the they are released and have a heads up on that. Mm-hmm. Shaming and control and manipulation. Mm-hmm. Yeah. But that one, I mean, these are all oddly specific. I don't know if these were actual cases or what, but I mean, catching the bed on fire and like, yeah. So, hmm hmm yep, exactly. It's like an isolation tactic. I'm going to make you feel really alone and unsupported in your community. Let me isolate you so I can further control you and manipulate and abuse. Yeah. All right. Mhm. Mhm. So I was getting all of that information at once. As an advocate, we would just break that down. So I would start to um, better understand, is she really not wanting, is she really wanting to stay in that relationship, or are the barriers that she's going to encounter after, is it, is she just wanting to um, stay in that relationship because she might not think there is an alternative? Maybe if she understood some of the additional support services that we offer here at SafePlace, it might change the direction where they're going, right? So maybe if I let them know about relocation, or if we can provide some sort of rental assistance, or um, maybe if they had that information, they would make maybe a difference. Um, So I needed to break that down. There's one point in there where it talks about the advocate from the prosecutor's office. Again, they are different advocates than we are. They have an agenda, and that's their partnership with the prosecutor. That's probably why they didn't feel helped in that situation, because they were wanting to stop the and that act is not stop process. They have a different, which is get the bad. Um, so uh, I would explain the difference between bad thief, our role here, and how we can support, and then kind of lay out options, and, but it would be blanket. Um, but if I provide options and maybe a game plan going forward, um, but maybe if she really just isn't concerned with her safety, then I'm not going to make decisions on somebody else's life. I'm going to hear them, and then we would transition into how to keep your self safe um, in that relationship. So what support can you offer um, that uh, can keep her in her home, in her relationship, in her ability, but also be safe. I also leave most of my conversations like that are regarding this and then not wanting to be involved in any court cases. I want to remind them explicitly that if anything else comes up, you come right back to me. I am a no judgment zone. I don't care if you come back to me tomorrow and a new situation happened, but you're maybe feeling embarrassed because you made the decision to go back to that relationship. We'll pick up right where we left off. Don't ever hesitate to come back um, to us if something else goes down, whether that's tomorrow, a month from now, a year from now. Uh, we'll start from scratch um, and address the situation that we good. But open ended, never judging. Let's work with what we got. Yeah, right. Oh, that's another point is they mentioned that they need to break their lease that'll jeopardize their credit score. When you are a victim of a crime, you can break your lease. If they have a no contact order, if they've got a protection order, all they need to do is literally give that to the whoever they rent from, and they immediately can break their lease and move. And it cannot affect their credit score or have any repercussions on their rental history. It's a law. So if that was a barrier or something they're concerned about, let's cross that off. It's right there. But any supportive services that we can get to help with a stable income and resources um, might might help. Um, if you want to read one? Yeah. Defense attorneys aren't fun. Um, It is pretty standard for defense attorneys to get to interview the witness regarding that, uh, but uh, they're not my favorite people. Defense attorneys are defense attorneys. Um, and it is very common for in those discussions, the defense attorney is there asking the questions, but normally they've got their own personal detectives that they work with. That's probably who is taking notes. And normally they don't say anything, but it's very intimidating. So I would just like stop politely and be like, "Can we go around and introduce ourselves real quick?" And I would have them identify what they're doing in the room. And yeah, and they'll just say, "I'm just a detective here taking notes." But if I was sitting there, that's very extreme. I would hope that that was probably like 30 years ago. But if that victim blaming, accusatory shit was going on while I was in the room, I would shut it down. Even that one question, and that's especially other people while drunk. Um, I would just politely stop, um, and I would either ask for the prosecutor to be present during that interview, because they might be taking advantage of the fact that there's no one of authority to. They might not know. Um, they're going to know I'm an advocate, but they'll push to see how far they can go. Um, and like one of my favorite quotes is "Speak the truth, even if your voice shakes." That would be scary for us as advocates to be in, but the victim also. But it would be my job to shut that down. You would either need to reschedule, they would have to change their accusatory language in that. And I would also follow up with whatever company they work for, even if it was their own. Um, I would follow up and say that communication is completely victim blaming and inappropriate and illegal. And if if I need to provide them some trauma informed training, then that would be something that I would call enforcement about. But some of that would be illegal. Um, I can't remember all of that quote by quote, but exactly, exactly. Yeah. So some of them are just all of them are inappropriate, but I think there was a few on there that was just outright illegal. Yeah, yeah. Um, and I would hope to think that people are better, but that is, I mean, very relevant and was pretty standard. Um, and I would follow up with the prosecutor. I would tell the prosecutor about that situation too, and you would the prosecutor needs to know how inappropriate that is. So another person would be in the room as good. Mhm. Yeah. Mhm. Yeah. Yep. Yep. Yeah. And as I give you some more structured training, that would be a conversation I would have with the client beforehand. If you're not comfortable answering a question, don't guess, just don't answer. And I would let them know that that is their option. But really, uh, that would be a voluntary. If they're not like under oath um, on stand, then what they're providing is voluntary. And criminal justice